Michael Kushner here. Welcome back to the podcast, HOA HELL. And with me is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. How are you?
I'm fine, thank you.
Good.
Sam, today we are going to cover a topic that is extremely important to a lot of people that live in an HOA. And it is a source of tremendous, when it's happening to you, it's stressful, and it can be disastrous. And what that is I guess we're going to talk about one of the most serious powers that an HOA has, which is the ability to place a lien on somebody's home and foreclose on somebody's home. Take it away. Okay?
Serious issue. Yeah. Mm-hmm.
It happens to a lot more people than you would, hope. Mm-hmm. I guess that's not the right term. It happens to too many people.
Right.
Sometimes because homeowners don't realize that the power exists, and for whatever reason they refuse to pay because they're upset or whatever it is, and then all of a sudden, their home is gone because they either ignore notices that come in or they don't take them seriously. You had a consult this week.
Heartbreaking.
Which I'm going to have you talk about in a second, okay?
Mm-hmm.
Just briefly, I want you to give me the story in a second. But that's what prompted us to do this episode, to be honest. We would have probably done it at some point, but we had a consult at the beginning of this week that was heartbreaking. And you know what? We've heard that story before, and it just came at the right time. I'm like, you know what? I'm going to put this at the front of the line. So that's what I did. So the secret's out, okay? HOAs, under certain circumstances, can take your property away. They can foreclose, just like a bank can do if you don't pay your mortgage. It's the same power. Now, there are strict conditions associated with it, as there are with a mortgage banker or mortgage lender. And so there are very specific steps that they have to take under the law. And if they fail to take any of those steps, because it's such a draconian remedy for them, then it's you can get your property back in many cases. There are limits on that too, but we're not going to get into that. Now, this is such an important and such a deeply complex topic. We could have easily done this in 3 episodes. We're trying to do it in 1. So number 1, this episode might be longer than normal. But number 2, we are going to leave certain things out. And there's a couple of things I'll identify later in the episode that we're just not going to talk about. We might do a future episode on it, okay? Right. Mm-hmm. So here's what we're going to talk about in this episode, if we have the time, okay? Number 1, why your HOA is obligated by law to assess its members, okay? Because that's important to set up. If they assess you and you don't pay, that's what triggers the right to lien and foreclose. So I want to describe, the law actually requires them to collect money from you. So we're going to talk about that briefly. And then we'll talk about the difference between assessments and fines. Because assessments and fines, that difference is extremely important under the foreclosure rights that an HOA has. So it's critical. We'll next talk about the difference between judicial and non-judicial foreclosure. Mm-hmm. We'll talk about what the pre-lien procedures are. Okay, so what procedures does an HOA have to engage in before they can record with the county recorder, becomes public record, a lien against your property, which is a prerequisite step to eventual foreclosure, okay? We'll talk about the legal threshold that HOA has to meet before foreclosure is an option. And then we'll talk about, and while we're at it, we're going to talk about the legal requirements during the foreclosure process that your HOA has to follow, because the word foreclosure can be very confusing. Some people use the word foreclose. I was foreclosed on, right? And they're talking about the day that they lost the property. That's the sale date. But there's a multi-month process, which is all called foreclosure. So the way we're going to use that term, it is a process. Right. So we're going to talk about the foreclosure process, okay? And I think the last thing we'll talk about is some proactive steps that you could take to protect yourself and your home, either from getting into that situation in the first place, or once you're there, what not to do and what to do, but definitely what not to do. Mm-hmm. And I'm going to go ahead and spoil one of those. You do not bury your head in the sand and hope it goes away. No. You don't ignore this, because if you do, you can lose your house. And that's a bad thing, okay? Let's first start with this. Let's talk about, sometimes you got to pay your HOA, okay?
Oh, yeah.
All right? So give me the 2 most common situations, Sam, where we have homeowners that are obligated to pay their HOA money. Mm-hmm. What are the 2 most common?
Well, the most common standard where they're obligated to, and you alluded to this at the outset, is their regular assessment dues.
So what is a regular assessment due?
These are monthly assessments that the HOA collects, or the board on behalf of the HOA collects from every single member. Right. And these go to common things like, common area maintenance, right? Or
so those are your general dues, your regular dues.
Right.
Those are the cost of, you live in the HOA, here's what you got to pay us every month or every quarter or however your HOA is set up.
And in most communities, it's on a monthly basis.
Yeah. And like in my community, in my HOA, we can pay monthly or we can pay quarterly.
Right.
And, it's just easier so not to remember every month. So, sometimes I do it quarterly, sometimes I don't. But yeah, it's that amount that you pay just as a matter of course. Okay, those are called your general dues or your general assessment or your regular assessment. Okay, all the same word. Okay, right. What's another kind of assessment?
Well, the other kind of assessment is special assessments, and we've talked about this. And these are when there's either underfunding or you have a special project, something that's unforeseen, and we have other great episodes that we've done on this podcast covering that in depth.
Or an emergency.
An emergency assessment. We discussed the balcony law, right? The SB 326, and in connection with those endeavors, the HOA may pass and levy a special assessment,
which is on top of your general dues. It's like, and it could be anywhere from $500 or $200 each home to $50,000.
Right.
All right, depending on what it is. But those are not scheduled. By definition, you can't plan necessarily for those 2 years in advance, but
Exactly.
you know what your dues are going to be, subject to increases every year that the board's allowed to implement under the Davis-Sterling Act. So, and now let me take the next two. There's a third situation where you pay your HOAs. We got the two kinds of assessments. Now we have fines. Okay, when you, depending on if your CC&Rs or any other governing documents, typically CC&Rs, authorize or empower your HOA to issue fines, then when you violate a rule or do something wrong in the HOA after a hearing, you can be fined. And so a fine is a situation, if you're fined, where you have to pay money. And the last one is if you or your guests or invitees cause damage to the common area, the HOA has the power to assess against you the repair costs as well as any other accoutrement costs that might come with that. And under the law, because this will be an important distinction, under the law, a repair reimbursement is considered an assessment and not a fine. It's not a punishment, it's a reimbursement. So that's considered an assessment for the Davis-Sterling Act purposes. But those are the four situations where you got to pay money to your HOA. You get fined, you broke something,
right,
or general dues or special assessments or general assessments. That's it, okay? Now that you know when you've got to pay your HOA, let's talk about some HOAs try to do, and that is HOAs sometimes, because they know that there's a difference between fines and assessments, right? They try to recharacterize fines as assessments. You're going to see why later. Again, that difference, we're going to skip the reimbursements for now because that was just, it's not really what we're talking about today. The big dichotomy today is assessments over here and fines over here. That's the dichotomy we're going to be going back to over and over again. And because they are treated very differently under the Davis-Sterling Act, many HOAs, and you've seen this hundreds of times, I'm sure, many HOAs try to recharacterize what should be, or it's clearly a fine, as an assessment because they'd rather it be an assessment.
Absolutely can't do.
Can't do it,
nope.
Right? Okay. Civil Code 5725 explicitly states, HOAs, you can't recharacterize fines as assessments. Don't even do it. It says that for a reason, because in the past they tried. Now, some bad HOAs still do, but not as many as there used to be, okay? But they have a specific statute on it because it was so common. So keep your eye out for that. But that's it. I just wanted to make that reminder. Now, we talked about the money that you four kinds of ways you pay your HOA.
Right.
Why are you paying your HOA? Why are you giving money? Because your HOA is obligated by law to collect money from you. Why would they need to do that? Well, we've talked in the past. What is among the three primary responsibilities of the HOA board in the first place? Why do they even exist?
maintain and repair common area.
There's
right?
one.
2, they serve as fiduciaries where they manage the finances and money
Yep.
coming in, which we are speaking of right now.
Yep.
And 3, let's see,
Enforcement.
enforcement, of
Right.
course, yeah.
Okay.
Governing documents.
Let's
yeah.
focus on that first one because that's the one that matters here. They are obligated under the Davis-Sterling Act by law to repair, replace, maintain the common areas in your HOA. That takes money. In addition, and in recognition of the fact that that takes money, the Davis-Sterling Act also says, hey, HOA board, in order to fulfill your obligation to maintain, repair, and replace the common areas, you must collect enough money to do that.
Right.
Whatever that is, you need to go and charge your HOA members enough to do that. Now, it doesn't say how much. It can't. It just says whatever it costs for you and your HOA to maintain, repair, replace those common areas, you are obligated to get that money from your members, so you better assess them. That's what it says. So that's why they are obligated by law to get money from you, because they couldn't effectuate the primary reason for their existence if they didn't have the money to pay the vendors, contractors, and blah, 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 and painters and all that stuff to do whatever it is has to be done.
Right.
So it's that simple. Now, there's another component to this that I'll just say in passing. I'm not going to spend too much time on it. If an HOA board were to allow its feelings maybe to get in the way of its obligation to collect money from the homeowners, okay? And if somebody wasn't paying, to let it go, to let it slide, that could come back and bite every single homeowner in the community. It could be a very big problem, and here's why. Under most, I would say the vast majority of loans, other than well, let's just say the vast majority of loans for properties that are in an HOA in California probably are FHA backed. They're backed by the federal government, okay? The FHA guidelines specifically state that if an HOA has higher than 15% failure to collect, so assessments levied versus their collection, if that failure is 15% or higher, that is, they have a debt of 15% or more on their efforts to collect the assessments that are due, the FHA will no longer back any loans for houses in that HOA. And if that happens, you're screwed.
Serious
Good luck
stuff.
selling your unit, because most people, unless you're in a jumbo loan, and most aren't, most people rely on FHA-backed loans.
And by the way, they're so serious about it that they provide for only 60 days of delinquency.
That's
so
right.
if it's only 60 days or more delinquent, not a year or longer.
Good point.
Yeah.
Good point. He's right about that. In other words, it's not just, okay, if 15% or higher and it's after a year. No, it's 60 days. If 15% or more of the members of your HOA are 60 days past due on the collection of assessments, not fines, assessments, the FHA will no longer back any loans. And that means you're not selling your property unless you get some investor coming in to pay all cash. Yeah, if you get a cash buyer, sure, it doesn't matter. But most people aren't cash buyers. So that is a major, major problem. So that alone would be enough to justify HOAs to act. So now that we've gone there, we've talked about that. We talked about the difference between, we talked about the dichotomy between assessments and fines, and we told you keep that in the back of your head because that difference is going to be monumentally important. Well, here's why it is. And this topic I'm about to talk about, I have a short. So if you can go watch a 1.5-minute video where I give a very quick description of the difference between what I'm about to talk about, or you can listen to me right now and skip that other one, or do both, whatever floats your boat. But now I'm going to talk about the difference between judicial and non-judicial foreclosure. Okay, I'm going to have Sam talk to me about non-judicial foreclosure. What is non-judicial foreclosure, Sam?
Non-judicial foreclosure is basically the more fast-track process of lien enforcement. So once there's a delinquency or failure to pay on your dues, and the HOA can legitimately record a lien against your property, right, that tracks with your property, they can basically, they don't have to go to court. They will proceed with what's called a non-judicial foreclosure process being the operative word.
Don't go into details on the process. We'll talk about that later.
Right. And they essentially can use a designated trustee, they're called a trustee, to assist with that foreclosure proceeding. Right. And they have certain requirements as far as notice requirements, which we'll get into. And so that allows them to fast track it and do it pursuant to certain statutes that are operative and a certain time frame where there's certainty as opposed to some degree of uncertainty with courts and delays that you may encounter with courts. And so that allows them to just simply go ahead, provide you the requisite notices, and proceed with that foreclosure.
And a lot less expensive because you're not hiring lawyers and there's no lawsuit here. So here's the important takeaway on that. Non-judicial foreclosure is the ability to take your house without having to go to court. Now, that might sound very familiar to you, because it is. Yeah. That is the same power that any mortgage banker has when you don't pay your mortgage. If you don't pay your mortgage, your house goes into foreclosure, it's a non-judicial foreclosure for the most part.
Right.
In almost every situation, 99% of the time, you hear about a person losing their home to foreclosure, it's through non-judicial foreclosure, because that right is one of the rights granted to a mortgage lender that lends money on a house, right?
Exactly
so
right. Yep.
That's something that you're all familiar with. Even if you didn't understand that's what it was called, now you know. It's the same thing, okay? Now, let me talk about the other thing. So he's talked about non-judicial foreclosure. I'm going to talk about judicial foreclosure. Judicial foreclosure is exactly what it sounds like. You are foreclosing via judicial action. In other words, judicial foreclosure is the lender, in this case the HOA, or it could be a mortgage lender if they wanted to go that route, filing an actual lawsuit against the borrower, or in your case, the HOA member. And in that lawsuit, the primary cause of action is to foreclose. It is a regular, full-blown civil lawsuit, meaning you prepare a complaint. The lender will prepare a complaint and file it with the court. Let's say there's only one cause of action, foreclosure, okay? Well, just like any other civil case, regardless whether it's a personal injury case or it's a business torts case or defamation, the defendant once served has 30 days to respond, and then there's pretrial, there's, all these motions that can go on forever. There's discovery, depositions, written, interrogatories, all the regular stuff. That's all there. Judicial foreclosure is basically a lawsuit to foreclose. There's no trustee here. There's no fast track. You are taking the long road, and post-COVID, that's at least 2 years, maybe longer, depending on what county you're in. If you're in Orange, LA, Riverside, San Bernardino, San Diego, you're going to get a different trial date. But it is a much longer process. It is much more expensive because typically, at least one side, the lender is certainly going to have a lawyer, and a homeowner that actually fights it and appears in the case is going to probably have a lawyer. But the bottom line is, it is by no means the fast track, and is by no means, it is involving the courts. Now, unfortunately, just statistically speaking, more than you might think, defendants in a judicial foreclosure never even respond to the complaint, in which case it isn't very slow. It's faster than non-judicial. If your HOA or lender files a judicial foreclosure and you don't respond within the 30 days after service, they can get a default against you and actually get a judgment in much less time than and then exercise that judgment as a means of non-judicial foreclosure. Because once they have a judgment, they can non-judicially foreclose. So then that starts that process. So it behooves you to answer, but that's all we'll say on that, okay? That's part of the don't ignore and bury your head in the sand, okay? Mm-hmm. But that's the difference between judicial and non-judicial.
Yeah.
One of them is using a trustee and skipping the court process altogether, and the other one is just via a normal lawsuit. And there are differences we're going to talk about later on what happens on the back end, at the end of a sale, whether it's judicial, non-judicial, there are some differences. But that is the main difference. Lawsuit versus no lawsuit. Fast track versus no fast track. Right. Shortcut versus no shortcut. Okay? Both pathways, judicial, non-judicial, lead inevitably, if successfully done, to the same place. Homeowner loses the house. They end up in the same place at the end. But how they get there is very different in terms of timing and in terms of requirements. Yeah. That's the main takeaway of this, okay? Now, let's start with, we're going to back up now. We just talked about the difference between non-judicial and judicial foreclosure. How do we get there? Well, we get there because the HOA is interested in putting a lien on the property, because that's the first step, okay? So let's talk about what's an HOA lien. What is an HOA lien?
Well, an HOA lien is essentially an instrument that's recorded against your property.
What does that mean?
But what it is once a homeowner, a member, is delinquent or in default in terms of paying their dues, and those dues amount to a certain threshold, we'll get to that. Mm-hmm. The HOA will then have the right or the option, and in most cases they exercise the option, to commence recovery proceedings against you. You'll get a demand, and then that demand typically leads to...
Talk to me just about the lien.
Yeah.
What is a lien?
The lien is, like I said, it's an instrument that articulates what debt is owed to the HOA. Mm-hmm. That, without getting into the, pre-lien requirements, that gets recorded against you and your property, right? It specifically tracks and runs with your land. It references your APN. It gives any potential creditor or prospective buyer constructive notice by virtue of it being...
So let's stop there for a minute.
Right.
Let's stop there. So this lien is a legal instrument. It's a document that is recorded with the county recorder, that as soon as it's recorded, it becomes part of a public record. Anybody doing a search of your property, either by address or he used a term called APN, that's assessor's parcel number, but you can do it by address, would see the lien pop up. The second it was recorded, it would pop up on a search by, for example, any title company or any title insurance company, or anybody that wanted to run a property profile. After a lien was recorded, will see that lien. And what that lien does is says, hey, everybody in the world, we are owed money. Here's how much. And you can't get this property without paying us, okay? We get paid off the top before anything you take is subject to our rights here. In other words, it puts the world on notice that this debt exists so that nobody can buy the property and then say, well, we were surprised. We didn't know there was a lien. Well, it's public record. Whether you search for it or not, it's your business, but it's a public record. Yeah. It's a very big deal because it makes it impossible for you to refinance the property, for example, unless there's sufficient money to pay off that lien, because no lender is going to lend on that. No lender is going to refi knowing that there's this lien out there. Now, there's tax liens. It's the same thing. Okay. There are lots of different. There's judgment liens, which are obtained by people that have a judgment against you. It's just a record against the property, and it follows that property. It's there forever until it's been satisfied, and then it goes away. So that lien puts the whole world on notice that you have X amount of money that's owed, and it also implicitly puts everybody on notice that they're gearing up for something else, which is what we're going to talk about. Now, during Sam's discussion of what a lien was, he alluded to some requirements that are called pre-lien requirements, and we're about to get to those, okay? And he also alluded to a couple of requirements, some thresholds that have to be met. So let's talk about that. I'm going to take the first one, and then I'm going to have Sam take the second one. Now, HOA that's owed money by you, here's the default. HOA, you owe HOA money and you haven't paid it, they can record a lien against you. But only if one of the next two conditions is met. Condition one, the debt, the amount owed to the HOA is $1,800 or more. So if the debt is, let's say there's an assessment of $500 and you don't pay it, they can't do a lien on your property for $500 unless, at least under that first condition, it doesn't qualify because $500 is absolutely less than $1,800. But there's an or. So it's either $1,800 or more, or, Sam.
Yeah, that second threshold, the alternative to the $1,800 total debt amount or more, is if you have 12 months of missed assessment payments. And that can be theoretically below that $1,800 threshold. Hypothetically, if you had a $50 monthly assessment and 12 months missed
or
would
$100,
be, or even $100. I mean, at $100 it would be $1,200, right?
Right. In other words, just give us in other words. In other words, if you are at least 12 months late on your assessments, which at $100 a month would add up to $1,200. Right. That's less than $1,800.
And just to clarify, if you're 12 months late on a singular or maybe a couple missed assessments, that's not adequate and doesn't satisfy that threshold.
Unless it's over $1,800.
Unless it exactly first one. So it'd have to be 12 missed assessment payments.
Right. And it doesn't matter what the amount is. If the assessments are $50 or $100 a month, it's going to be at the end of the year. It's going to be less than $1,800, but it qualifies under the or. Okay. But it can be far less than a month or far less than a year if the amount happens to be $1,800 or more. Yep. So in either situation, once one of those thresholds is met, or both, but one of those thresholds is met, the HOA can go ahead with the pre-lien requirements with the intent to actually record the lien. So, and by the way, a lien doesn't require a court order, okay? It's not a lawsuit. It's not a foreclosure. If all that ever gets recorded against your property is a lien, if nothing ever follows, there's no foreclosure, okay? A lien by itself is not a foreclosure. It is a necessary thing, but it is not a foreclosure in and of itself, okay?
It essentially secures the debt, secures it.
It puts the world on notice, and therefore it acts as a security, okay? Now, I would argue, and I think I've said it, but I want to be clear, that if the HOA is interested in eventually pursuing foreclosure, the first step they will start with that's official is the recording of a lien because they want to preserve their rights.
Absolutely.
Okay? So, first step. Let's talk about the pre-lien notice requirements because that is something Sam brought up before. Usually this is pre-lien. So this isn't the lien itself. Okay? This isn't the instrument that Sam referred to. This is usually in the form of a letter from the HOA, and the letter is going to follow very strictly legal requirements that are necessary to be followed before a lien can be recorded. And these are in addition to the $1,800 or 12 months of assessments, whichever. This is not that. These are in addition to, okay? Let's assume one or both of those conditions were met. That doesn't mean that, okay, right now we could go ahead and record a lien. No, that just means you can go ahead and do this next part. So once you've gotten beyond the $1,800 or it's been more than a year, regardless of the amount, now you can move forward with, okay, we're starting the lien process with the pre-lien requirements. So the statute to look at here, if you're interested, is Civil Code 5660, okay? HOAs can record a lien, and they have to serve you, before they can do that, with a pre-lien notice, at least 30 days before they serve a lien and record a lien, okay? So 30 days. Now, that decision to send the letter, the pre-lien letter or not, and this is something that a lot of people don't realize, has to be made by the board, of course. They're the ones that are in charge. And it cannot be made by the board in executive session, in private, where they discuss lien. You know, who should we go ahead and pursue a lien, against who hasn't paid? And the reason they can't do that, it's not one of the 5 things that was listed in what can be discussed in executive session statute. I have a short on that. If you go on to the YouTube channel and you look at the shorts that I have, you'll see one of them is what can be discussed in executive session. No, not executive session. The discussion as to whether or not to proceed with a pre-lien notice must be done in open meeting. That means any homeowner can attend, okay? Now, there's nothing in the statute that requires the HOA to state the name of the person that's the subject of the pre-lien notice, but there's also nothing in the statute that says they have to preserve the privacy of that person. Unlike other issues which are specifically protected, privacy issues that are protected under the Davis-Sterling Act, there's no protection for the name of somebody that's gotten to the point where they're going to do a pre-lien notice. And that's because they're about to do a lien, which is public record. So the law doesn't see a privacy issue there. And I can see the logic of that, okay? Yeah. But here's what's important. Some HOAs keep it private and they only discuss, all right, let's discuss property that has an APN of. They don't even use the address. They use an APN. Yeah. Which provides it, and it's easy to find out who owns a property by having the APN, but it's a step that a lot of homeowners don't know how to take or don't bother. And so it's a way to preserve privacy. But a lot of HOAs will purposely name the name. Let's discuss our pre-lien notice to go out against John Smith, okay? And the reason they'll do that is A, because they're unkind, maybe, or B, they want to shame somebody into paying, or even implicitly try to have other homeowners that are present in the meeting apply social pressure. Because remember, when you're not paying, you're actually not giving money to the HOA that it needs to do its thing, and that's a problem. And so some HOAs will embarrass people by using their name, and there's nothing illegal about it because this has to be discussed at open session, and there's nothing saying that they can't use a name. And because it's about to be public record anyway, the law is not going to see that as a privacy issue. So 30 days in advance, or more than 30 days in advance, the HOA has to meet an open meeting and discuss it. And if they vote to let's proceed with pre-lien notice, that notice has to go out at least 30 days before they can record a lien. Now, there are obligations that must be met under California law that accompany that have to be in the pre-lien notice. Tell me some of those.
Okay. So one, the pre-lien notice has to provide the basis for that lien, right? The debt owed. Oftentimes a ledger or basically a statement of an itemized breakdown of what that constitutes, right? Because you have to have a valid basis, like we discussed, that threshold has to be met, and it has to be the right kind of assessment. It can't be for fines or disciplinary punitive components.
It can be for fines. You could do
it can be, but I'm saying that threshold cannot exclusively be met by way of fines. Right. The second thing is it needs to put them on notice of the legal implications of this, right? Even though it's a pre-lien notice, it's not a lien yet, but it's essentially the first step in commencing that process that we discussed. So it needs to put them conspicuously, very obviously on notice that this may have adverse legal implications, such as you potentially losing your property by way of a foreclosure.
In fact, the statute that you're talking about gives the specific language that has to be used verbatim and tells us what font size it has to be in.
Right.
It has to be in 14 point.
Conspicuous, obvious. It has to pop out.
14 point. And the example given in the statute itself is in all caps. And there are specific words. I'm not going to recite those, but it's basically, hey, this is the first step toward you eventually losing your house at a foreclosure. So take this seriously and pay attention. So one of the things he listed was it has to give the basis of whatever the amount is that's being liened, the amount that's due. So obviously it has to state, here's the debt. You owe us X amount of dollars. And it's from this, or this, or it's from this, and this added up. Whatever it is, the amount and the basis for it, okay? It has to be sent by certified mail, doesn't it?
Yeah, it does.
Okay? Which is a good thing, by the way, because anybody can say, oh, I dropped it in the mail. If you didn't get it, it must have been the mail. You can never prove that, right? It's he said, she said. Certified mail at least puts it on the post office. Now, the law doesn't say it has to be return receipt.
No.
It just says certified or registered mail.
Right.
But that's still pretty good. So it has to be sent by that, okay? So it has to also include a statement in there reminding you about, hey, by the way, you have a right to ask for and receive and inspect the financial records of our HOA. So if there are any financial records you feel are relevant to you, you have a right to ask for them. So don't forget you have that right. They have to remind you of that right. What else do they have to remind you about? Another right.
They also have to give you a notice and provide you language that affords you some ways to resolve this debt and avoid progression of this in terms of it.
Right. What is one of the things that they have to remind you about?
One of them is you have a right to an IDR.
Yeah. We've talked about IDR a million times and a million. I say a million, I'm obviously exaggerating, but we talk about IDR in almost every podcast.
Right. Internal
dispute resolution. Even though they remind you of your IDR rights, they being the board, every year in the annual disclosures, in the event of a pre-lien notice letter, they have to actually put that in the letter. Oh, by the way, in addition to your right to look at financial documents, you also have the right to engage in ADR with us if you want to. They have to remind you. They specifically have to say it out loud, okay? Yeah. And they got to go further than that. They got to go, and you also have the right to ADR,
right?
Okay, which is a higher step. ADR is in context of the HOA, it's mediation, okay, which is informal settlement talks before a neutral, where that costs money. You probably have a lawyer with you. They're certainly going to have a lawyer. It's very official as opposed to IDR where there's no lawyers, okay, and it's free. ADR not free, okay. Somebody has to pay the neutral.
Right.
So they talk to you about that. They have to mention that, okay? Now, if the HOA skips any of those steps, if the pre-lien notice is sent via regular mail, or the pre-lien notice doesn't include your right for the documents, or doesn't list the amount properly, or the basis of the amount, or doesn't provide you your right to IDR, it's very arguably ineffective, and you can have, and if they then rely on that pre-lien notice to record a lien, you could have that lien expunged.
Yeah.
Okay?
Yeah.
These are strict statutory obligations that have to be followed very, very strictly because what they are contemplating is so draconian. Okay? Then, once they've complied with those and the 30 days passes, if the debt's not paid, they can record the lien.
Yeah.
Now, we'll get into this later. We're going to talk about some of the things, if you find yourself in that situation, some of the things you should ask for to maybe kind of alleviate or put a halt to part of this process. And it may or may not work with your HOA every particular time, but we'll give you some tools. But that's the long and the short of it. Mm-hmm. If the letter contains all the things it's supposed to contain, and it's gone out at least 30 days before, once that 30-day passes, they can record their lien. Now, boom, public record, okay? So let's say nothing happens once the lien's recorded. You don't reach an agreement, you don't pay. At some point after the lien has been recorded, the decision will be made, okay, we're going to foreclose. We're going to foreclose. Remember, there's two ways to do that. There's two avenues for foreclosure. So we're going to go into those right now, okay? Non-judicially or judicially, okay? Non-judicial foreclosures taking this path down to the left, and judicial foreclosures taking this path down to the right. The HOA, regardless of what, the HOA can, in many cases, make the decision if they have a choice. And we'll get to that in 1 second. So let's start with non-judicial foreclosure. How do they work? How does a non-judicial foreclosure work from beginning to end? I'm going to assume for the purposes of this discussion that the lien that was recorded is not part of the foreclosure process. It is a precursor. So in my opinion, the foreclosure process starts now. Mm-hmm. Okay? Although some people might say, no, I include the lien, which is fine. You can do that if you want to add a step. That's okay. There's no right answer to that. Okay? So non-judicial foreclosure, let's start with the most basic thing, and I think Sam may have said this earlier. And if not, then I'm saying it now. An HOA cannot utilize the non-judicial foreclosure route to collect anything other than an assessment. Okay? Which would mean a general assessment, a general, unpaid general dues, or a special assessment that's been unpaid, or an assessment for reimbursement, a reimbursement assessment. Somebody broke the whatever, okay? Non-judicial foreclosure cannot be used if the debt in question is a debt of fines, if that's the basis of the debt. So it has to be non-payment of assessments, not fines. That's number one. And remember, those two requirements still exist, the $1,800 or the 12-month thing. Those are still there, okay? So you have to have met one or both of those requirements. Now, let's say you've met the threshold. It is unpaid assessment, and it's more than $1,800 or it's been more than a year of non-payment of assessments, okay? Those thresholds are now met. What steps do you follow to effectuate from beginning to the end of this non-judicial foreclosure process, which, given the timelines involved with the code that we're going to talk about, nowadays, this is a change that came into effect in the last 12 or 13 years, but certainly after the crash of 07, 08. But it now takes about a year. A non-judicial foreclosure, when the bank is moving, or not the bank, the HOA is moving as quickly as they can, is about a year. And here's why. Step one, you have the board vote in open session. Hey, the lien didn't accomplish much. Let's move forward with foreclosure. Mm-hmm. Okay? So again, open session. They can use a name or they can choose not to. The next step is something called a notice of default. Now, the real name is something akin to a notice of default and election to sell under deed of trust.
Right.
That's the full name of the document, but it's known as the notice of default, or you might see it as all capital NOD. Any of those three. Yeah. Okay? If it's got the word notice of default and blobby, 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 election to sell under deed of trust, okay, that's just a formal name. But NOD, notice of default, that's what we're talking about. And that is a document that is recorded with the county recorder, just like a lien is. And that document says, hey, world, this property, and it gives a legal description, it gives your APN, probably gives an address, has a debt owed to whoever, in this case, your HOA, of this amount of money. Okay, and there's a lot more junk in there. That thing has to be recorded with the county. It has to be tacked on your door, or if there is no door, if it's just like raw land, I guess, onto a post on the property. But it has to be affixed to the property, and it's got to go out via registered or certified mail. Now, for those people who have received notices of defaults in the past, they can probably attest to the fact that in an abundance of caution, the trustee usually serves 10 or 15 copies of the notice of default. Yep. They'll mail it they'll do it by certified, they'll post it on the property, and then they'll send it by regular mail, 7 or 8 days in a row. So it's lots of copies are going to come through, okay? But that's basically what the notice of default is. It basically says this property or this person owes this much money to this person, and if they don't pay this in the time that, in the description below, at some point we're going to proceed with the next step, and eventually this could be lost at foreclosure, and it's got all this language. It's very scary. It's very scary sounding language, okay? Now, once they record that NOD, how long before they can go to the next step? By statute, they can't do anything else.
Right.
Other than work with you if you want to try to come up with a solution.
90 days.
90 days.
90 days, yeah.
Okay, 90 days. Basically 3 months. 90 days, okay? They cannot go to the next step for 90 days. So during that 90 days, all that's happening is you're probably going to have a lot of some legitimate, most illegitimate scams and con men and con companies try to get you to hire them to help you negotiate the debt, or we'll buy your property for you and get you out of foreclosure, or we'll lend you the money at 25% interest, whatever it is. Mm-hmm. Don't fall for those. Just deal with your HOA, okay? But the bottom line is they sit on that for 90 days, okay? And during that time period, hopefully you're working hard to get yourself out of the fix, okay? Now, if nothing gets resolved, at the end of that 90-day period, anytime from the 91st day onward, it doesn't have to be 91st day, the HOA can wait till the 98th day or the 117th or the 147th. But if they wanted to move quickly, 91 days, because the next day, you get 90 full days. The next step is what? What is recorded next?
They can record a notice of trustee sale.
Okay, so the first one was a notice of default, election to sell under deed of trust. The second document, at least 90 days after that NOD, is the notice of trustee sale. Mm-hmm. That notice differs pretty much from the notice of default by giving us some additional information. And what is that additional information?
Well, first off, both, I think you said this, but I'll just make it clear. Both will refer to the underlying notice and the recorded delinquent claim of assessment lien.
Exactly.
They'll give you the recording number for that legal instrument. They'll give you the total debt as of that recording.
Right.
Now,
which has to be updated because interest is accrued and other costs have accrued.
Exactly.
So you always have to call and get a payoff demand.
That's right.
But that's going beyond. I don't want to go into.
And once they record that lien, all of those additional fees and the recording fees, and the collection fees get added on. It's recoverable.
I want you to stay very basic.
Yeah. Mm-hmm.
What piece of information is delivered in a notice of trustee sale?
The date of the trustee sale.
And the time.
And the time.
And the place.
And the place.
It'll literally say, your house or condo or whatever it is going to go up for sale, public auction on this date, at this time, at this location. It could be the courthouse. Mm-hmm. It could be somewhere else. As long as they tell you where. They have to give the date, time, and location. That means that notice is telling everybody, you included, that a trustee is actually going to hold an auction to sell your house, and they're telling you when and where and what time. Now, that sale date that they put in there, your house will be sold on this date, has to be at least 21 days after the date of recording. So if they're going to record it on the 1st of the month, the sale date can't be on the 14th of that same month, because that'd be far less than 21 days. So at least 21 days after, okay? So once that gets recorded, you still have 21 days to act, okay? Now, we're not going to talk about the 5-day rule. We're not getting into that. This isn't a podcast on mortgages or on non-judicial foreclosure. So we're going to skip that. We're going to get to the sale, okay? And we're not going to talk about credit bids. We're not going to talk about, investors. We're just going to talk to the sale date. If nothing is resolved and this isn't taken care of before that sale date hits, and the sale goes forward, sometimes they're continued, okay? But if that sale date goes forward, somebody is going to purchase the property. It might be the HOA gets it automatically, and that's called a credit bid, and I'm not going to talk about what that is. Or it could be a third-party investor is the highest bidder. Whatever the case is, that property is going to be sold. Now, here is where you have a reprieve, partially. this used to not be in the law, and it was added within the last decade and a half, right, is something called a redemption period, okay? Here's what that means. It used to be that at the sale, the trustee, let's say an investor purchased at the sale. Investor would literally write a check for the come in with the cash, right? Or a certified check. They've already, they plan these. And these are people that do this for a living. And that day they'd get what's called a notice of trustee's deed upon sale. And they own the property that day. Trust that whatever company that is, let's say, now is the title holder of that property, and you're off that property. Okay? That's changed. What happens now is, for 90 days, okay, the property isn't transferred. It is held, the title is held by the trustee, but it still remains where it is, okay? And that 90-day period is called a redemption period. And that 90-day period is a chance for you, even though you didn't get anything done during the lien, you didn't do anything during the notice of, the 90 days between the notice of the NOD and the trustee's notice of trustee sale, and then you didn't actually do anything in that 21 days. You still have 90 more days to pay everything off, come clean, and bring yourself out of foreclosure. If you don't do anything during that 90-day period, then title is gone. It's no longer in your name. Property is transferred to whoever took the property, and that's it. You have a chance to pay off your property in that 90-day period. And that redemption period, that's why they use the word redemption. It's your last chance at redemption, okay? Is there anything you want to add to that, or did I state it succinctly enough?
No, that's really good.
Okay.
I mean, once that trustee's deed upon sale is recorded after that redemption period, title vests in that grantee.
You're done, okay? Now, assuming all statutory formalities were followed, you're not going to unwind that foreclosure sale. It's a done deal, okay? Now, I'm not going to talk about, here's one of the things I said I was not going to talk about. I'm going to identify it. There's a big deal about whether or not, if the sale price isn't enough to pay off the debt, whether or not there's a deficiency, whether or not you can be held liable. I'm not going to go into that deficiency judgment or money judgment. I'm not going to do that right now. I'll do that some other time. Critical takeaway is that non-judicial foreclosure cannot be used to recover fines, and as long as it's followed properly, property's gone. Okay. Now we're at 49 minutes, and we still have some stuff to talk about. So we're going to be a longer episode. So I'm going to speed up a little bit. Okay. Judicial foreclosure is the lawsuit version. So what has to happen? First step. Remember, non-judicial was the NOD, right? The first step here is you file a lawsuit. Let's say it's for fines. Remember, fines can't be the basis of a non-judicial, but assessments can be the basis for a judicial if the creditor wanted to go that way. But fines, that's their only option. And so we're going to pretend it's fines today, okay? Mm-hmm. Judicial foreclosure starts with the filing of what's called a verified complaint. A complaint is a fancy word for the lawsuit. It's the document that gets filed that lists the causes of action against you. All verified means is the allegations set forth in the lawsuit, in this case that we want to foreclose, have to be done under oath. So the representative from the HOA is going to verify under oath, under penalty of perjury, that the allegations set forth in the complaint are true. That's what a verified complaint means. So most complaints aren't verified in California. Most civil lawsuits aren't verified. This is one of the kinds it has to be, and it will be, okay? So they file a lawsuit. Then they get it served. Just the regular way. They have process server go out and serve it. You have 30 days you can demur, you can file an answer. I'm not going to get into any of that. For the rest of that case, until there's a judgment, it is regular civil litigation. So we're not going to talk about any of that. Okay? There can be depositions, there can be discovery, written discovery, there can be pretrial motions, there can be summary judgments, and there can be amending, and it's just a regular lawsuit at that point. So we're going to skip all the way to the end. A judgment. The court rules, it gives a judgment to the HOA saying, you may foreclose. Okay? I find there's sufficient evidence to justify the foreclosure. It gives a judgment of foreclosure. Okay? There's a redemption period here, and it's a little different than in a non-judicial. What's the difference, Sam?
Well, Well, first off, the sheriffs execute that, right? I mean, they commence with that process.
What's the difference in terms of the redemption rights?
Well, the redemption rights here is up to a year.
It can be.
It can be, yeah.
Under what circumstance? It's 90 days.
So long as they can fully satisfy and essentially take care of any other senior lien holders as well.
Okay.
Yeah.
So let's talk about that. If whatever the sale is enough to pay off not only the HOA, but any senior lien holders, like your bank, your mortgage lender, if it's enough to pay off all of that, all the costs and everything that it's associated, any senior lien holders, then you have, as you did with non-judicial, you have a 90-day redemption period. It's the same thing. But if the amount that was received either at bid or if it was a credit bid, right? And there isn't enough to pay off, then it's a 1-year redemption period.
Yeah.
Okay. The 90 days used to not be there at all. So judicial foreclosure used to always be 90 days or 1 year. So that's important. In that scenario, if the property was underwater, for example, you would have a 1-year redemption right. Okay. But the redemption rights, what is redemption, is all the same. It's your way to figure out how to pay that off. Borrow from family, do what you got to do, get your house back. Okay. Now, how do you dispute or resolve a debt with your HOA? Sam, you wanted to remind everybody, and since we're really out of time, do this quickly, but what did you want to remind everybody about?
Yeah, we discussed this briefly before the meeting, but basically a lot of homeowners who come to us in consultations, actual clients, oftentimes these types of conversations relating to this particular issue relate to, do I have a right to offset? For instance, if they have a
that's how they gotten in the problem in the first place.
Exactly.
They were pissed off.
So unfortunately, they wrongfully withhold dues
because they have a dispute,
thinking they have a colorable title, an actual legitimate claim for other things unrelated to the underlying debt.
That would reduce the amount that's owed.
Exactly.
That would offset,
but we religiously tell them, and we discuss this, and I'll just leave it at this for our purposes now. You cannot do that. There's no right to offset, and we religiously discourage that. We say no, stay current, pay off what you owe. Do not play games with this because they have dire consequences.
Right.
We will deal with the other stuff separately.
Right. So bottom line, guys, is you don't have a right to offset. So even if you are completely dispute the charges levied against you, even if they're completely illegal, and you believe you can prove it, and you might be right, you still pay it. Paying it does not waive any rights. Paying disputed funds, it doesn't matter. If you pay, you don't have to even write under protest. Just pay. And then if you want to sue later or go after the HOA to prove that that money was wrongfully taken, you'll get your reimbursement. Don't worry about that.
Yeah.
Okay? You'll get that. But you got to pay. You can't withhold payment because that's how a lot of people get in this situation by withholding payment when they shouldn't have because they think they have a right to offset. You don't. Specifically under Davis Sterling, you do not have a right to offset. Always pay, even if you know for a fact that what they're demanding from you is illegal. Okay? Even if, for example, the special assessment that they are seeking collection of, that you're refusing to pay, was completely illegal. You pay it, and then you take action to dispute it. And if proven correct, you'll get your money back. Don't worry about it. Okay? But if you don't pay it, they are within their legal rights to take that house, and you could lose it even though you were right. Don't be one of those people. Okay? So if you find yourself in this situation, always, just like you were reminded to in the pre-lien notice, request IDR. Sit down with a board member or 2 or 3, whatever, and discuss the issue. Ask them, can we work out a payment plan? I can't afford to do a lump sum here. Can we work out a payment plan so I can pay my regular dues every month and then maybe an additional amount that'll get me caught up? If the HOA, they don't have to agree to that, but if they do agree to that, that pulls you out of foreclosure. Okay, it pulls you out. So you really, really, really want to see if they'll do that. It couldn't hurt. Worst case scenarios, they say no. But ask. If IDR doesn't work, you might want to try ADR. But remember, ADR has a timeline that could be about 4 months. So even if you do that, you still have to act because nothing's going to stop. That timeline, that clock is ticking. So IDR at the very least. Demand a full accounting. They should have given you one. But if you want more than that, if you want more than they put in the notice, demand a full accounting. As far back as you feel is necessary to figure out so you can track the amount. It should have been in the original thing, but if you're still confused, get clarification. Next, challenge in writing improper fines or improper late fees or improper attorney's fees or improper assessments. Put it in writing to set yourself up for later, but remember that can't be an excuse to offset.
That's right.
But you do want them to be on you might as well get an admission from them or lack thereof that we can't support the debt. Okay, so if you know that you're right and it was illegal, put it in writing. Okay, explain why. Okay, remember AB 130, for example, which we've talked about in a prior podcast, and I've got some articles on my website about. One of the good things, I guess, that AB 130 managed to do is it barred late fees, penalties, and interest from accruing on unpaid fines. Right. So, guess what? If those things are included in, let's say that we're talking about a fine, demand they be removed. Put it in writing. Say under AB 130, you can't do that. Fair enough. Okay. Now, and then again, offer a payment plan. See if they'll bite. Worst case, no. How do you protect yourself? Well, most HOAs, not the bad ones, but a lot of HOAs that are run by decent people don't want to foreclose on you. And if you try to work with them, a lot of the time they're willing to work with you. Okay? HOA foreclosures often happen because the person at the other end, the homeowner, goes radio silent. They bury their head in the sand because it's too stressful to deal with, and they hope it'll go away, and it doesn't, and it just gets worse and worse as time goes on. So do not bury your head in the sand. Take an active role. Get a friend to help you if you need encouragement. Get a friend to help you organize, but do try to work something out with the board. Get involved. If you don't go silent, you have a much better chance of dealing with this, okay? Follow the steps we talked about above a few minutes ago. Respond to every notice in writing, okay? Keep complete documentation of everything, obviously. Understand your foreclosure-related rights by watching this podcast again, okay? And reading the article that I'm going to publish in a few days. And then take it seriously. And if foreclosure is on the horizon or has been initiated and you have the wherewithal, call an attorney like us at MBK Chapman. Get us involved. We can often help. We can be very helpful, okay? So, guys, HOAs in California have tremendous power to collect money that's owed to them because the Davis-Sterling Act requires them to collect money that's owed to them, to take care of the things that they are required fiduciarily to take care of. So they have powerful rights to collect money from you when you don't want to pay. And the most draconian of those is the right to take your house away. Mm-hmm. Gone. Bye-bye. You don't want that happening. So if they're threatening to take your home or they've started that process, don't bury your head in the sand. Deal with it. Call us. Get a friend involved. Do what you got to do, but save your house. If you like this episode, hit the like button. And if you haven't already done so, please subscribe to our channel, HOA Hell. If you'd like to leave a comment or you have a question, we'd love to hear from you. Please do that. Until next time, have a wonderful day.